Good afternoon. My name is Simone Chong, and I am here with my colleague, Jessica Diaz, and we are with the Los Angeles County Department of Consumer and Business Affairs. Welcome to the webinar covering the small claims process. In this webinar, you will learn the basics of small claims. The presentation provides information for both the party who is suing, called the plaintiff, and the party who is being sued, called the defendant. In the first part of the webinar, you will view a pre-recorded video. At the conclusion of the video, we will be answering your questions in a question and answer session. Please take note that your microphone is currently on mute. You may ask questions at any time during the video by submitting them through the chat box located on the lower right of the WebEx interface page. This webinar is being recorded and will be available on our website along with other small claims resources. Just go to dcba.lacounty.gov and click on the Small Claims tab. At the conclusion of today's presentation, we would like you to complete a 4-question survey to let us know how we're doing and give us any suggestions that you might have for future webinars. All feedback is welcome. Please start the video now.
Hello. In this video, we'll walk you through important steps in the small claims court process in Los Angeles County, from filing a claim all the way to collecting a judgment. We'll start by addressing the limitations and advantages of small claims court to help you decide whether small claims is right for your situation. If you decide to file a lawsuit in small claims court, you must be thorough and pay close attention to detail. The rules of court are very strict. Even minor or hard-to-spot mistakes can cause you to lose your case or your ability to collect a judgment in your favor. And since there are usually no lawyers involved in small claims cases, it will likely be up to you to avoid or catch these mistakes. But don't worry. We'll take you through the process one step at a time. We'll describe most of the process from the point of view of the plaintiff, the person or business claiming damages by filing the lawsuit. However, this video is intended to benefit anyone seeking a practical understanding of the small claims process. A few notes before we begin. 1. It's usually preferable to resolve a dispute without going to court. Any lawsuit involves aggravation, lost time, and the risk that a judge will not find in your favor. Consider taking advantage of mediation or other services offered by the Department of Consumer and Business Affairs before you file a lawsuit. At a minimum, you must reach out to the other party to ask for payment before you bring them to court. 2. This video is intended to provide procedural information, not legal advice. So, for example, we'll discuss the maximum amount for which you are allowed to sue in small claims court, but we cannot tell you whether filing a small claims case is actually a good idea in your situation. And keep in mind that you may need to do some additional research to fully understand some of the topics mentioned in this video. 3. This information is subject to change, especially during the COVID-19 pandemic. It is your responsibility to confirm that you have the most up-to-date information on court requirements and deadlines before you file your case. Let's start with some basic terms. Every civil lawsuit involves two sides, known as parties. The party filing the original lawsuit is called the plaintiff. The party being sued by the plaintiff is called the defendant. And these parties are not limited to individuals. Businesses and public entities, such as cities and states, may be named as parties. One significant exception is the federal government, which cannot be sued in small claims court. When a plaintiff sues a defendant in California, the case will be heard either in general civil court or in small claims court. Both courts are intended for a plaintiff who is trying to collect money or possessions from the defendant. If the judge decides in favor of the plaintiff, then the defendant will be ordered to compensate the plaintiff, but will not face a criminal penalty or have a criminal record. This compensation is called a judgment. Unlike general civil court, small claims court restricts the amount of damages a plaintiff can claim, depending on whether a plaintiff is a person or a business of one type or another. When an individual files a claim in small claims court, they can request no more than $10,000. When a business files a claim in small claims court, their limit depends on how many owners the business has. A business owned by just one person has the same limit as an individual plaintiff, $10,000. However, a business owned by two or more people, as well as corporations, can only file a small claims case for a maximum of $5,000. And no party can file more than 2 small claims over $2,500 in a calendar year. Let's take a moment to highlight an important exception to these limits. In response to the COVID-19 pandemic, the California legislature decided to expand the jurisdiction of small claims court in certain cases of rental debt owed to a landlord. Specifically, landlords may sue tenants in small claims court for any unpaid rent that came due between March 2020 and January 2021, regardless of the amount owed and regardless of the number of other claims the landlord has filed that year. Cases that fall under this exception will not be heard until March 1st, 2021 or later. If your claim falls within these limits, or you are willing to voluntarily reduce your claim in order to qualify, then small claims is an option for your case. For most plaintiffs, small claims offers a number of advantages over general civil court. For one, it's less formal. Lawyers aren't allowed, and neither party is expected to be a legal expert. You'll speak directly with the judge in plain language. Not only will you avoid lawyers' bills, but the filing costs are significantly lower for small claims cases, so the process is much less expensive overall. And the small claims process is also faster. Under normal conditions, a typical case will be decided by a judge within 3 months. Though the status of the COVID-19 pandemic when you file may extend this time considerably. So, what kinds of disputes usually end up in small claims court? Sometimes, it's one person claiming damages from another person. For example, after a car accident or failure to repay a personal loan. Other times, a person will sue a business or public entity for failing to provide a service or causing damage to property. Businesses might also sue in small claims court if they're paid with bad checks or for similar disputes with individuals or other businesses. However, depending on the type of damage the plaintiff is claiming, there are time limits that restrict how long the plaintiff has to file their case. The time limit for each type of damage is dictated by a statute of limitations. Once the statute of limitations on a case runs out, the defendant can legally request that the judge dismiss the case. Additionally, claims against public entities such as cities and counties require that you file a claim for damages with the agency you plan to sue within 6 to 12 months of the events in question. If small claims court sounds like a good fit for your situation, stick with us while we go through each step, starting with filing your claim. Filing your claim. You'll use a specific form to file a small claims case, SC-100. Many of the mistakes that cause problems for plaintiffs later on in the process actually occur much earlier in the process when filling out this form. Do yourself a favor here and slow down. When you're ready, locate the form on the California Court's website at courts.ca.gov and complete it while watching this video. If you need to pause or rewatch certain parts to ensure you've entered the correct information on the form, go ahead. For ease of reference, we'll go through the form in order from top to bottom. So let's take a look at the first page. Read the entire first page carefully, especially the instructions for the person suing towards the bottom. But don't fill in any information on this page. You will only complete pages 2 and 3 of this form. Turn to page 2. As the plaintiff, you'll enter your own information in section 1. If another person believes they are entitled to money as well, enter their information below your own. Section 2 is where you'll enter the defendant's information. You must enter the correct legal name of the person, business, or public entity that you are suing. Don't rely on your memory or spelling skills to do this. Failure to accurately name the defendant will jeopardize your ability to collect your judgment. In other words, you could win the case, but still not receive any compensation if you don't double-check this section. A person's legal name is found on their driver's license, passport, birth certificate, or other legal documents. A business's legal name can also be found in several places, depending on the business. Here are some common places to look. Corporations, limited liability companies, and limited partnerships that operate in California are required to register with the California Secretary of State. Use their business search page to find the business you're suing and confirm their information. Be sure to select the correct business type for your search. If you're not sure, try both options. You can also check with the City Office of Finance where the business is located for their business registration details. Also, the County Registrar Recorder Office may have documents on file that contain this information, either a fictitious business name statement or a grant deed. If you're suing a corporation, LLC, or public entity, you'll need to confirm the person or agent that should be served the court papers and enter their information too. This information can be found in the search results from the Secretary of State website. However, remember to leave this part of Section 2 blank in other cases, for example when suing an individual or a sole proprietorship. If your case involves a motor vehicle accident, remember to name both the driver and the registered owner of the vehicle. Note that, in order to name more than one defendant, you'll need to complete and attach Form SC-100A. For example, showing how to name different types of defendants, including minors, trusts, and businesses of various types, visit our website. In Section 3, enter the amount of money you believe you are owed. For example, if you were in a car accident, you can calculate the cost of repairing your car, and you can include reasonable car rental fees while your car is in the shop. If you took your car for oil and lube at the mechanic, and they put in a faulty oil filter that damaged your engine, you can sue for the original cost of service plus the damage caused to the engine. If you suffered personal injury, you can sue for doctor's bills as well as for lost wages from missed work as a result of the injury. Only include the amount of the original damages, not any court filing fees or anticipated post-judgment costs. If you win your case, the law does allow you to add these costs to your judgment afterwards. And don't forget, there are limits that we discussed earlier. If you are suing as an individual or as a sole proprietorship, you can request a maximum judgment of $10,000. Enter the rest of the requested information in Section 3, as well as Section 4 on the next page. Sections 5 and 6 ask about the court location, or venue, where you plan to file your claim. Different courts are allowed to hear cases from different parts of LA County. If the court location where you file does not accept cases from the zip code you enter in Section 6, the clerk will not accept the case. You must enter a zip code that matches one of the options in Section 5, including where the defendant lives or does business, where the damage or injury took place, where the contract was executed or is to be performed, or other locations offered on the form. Once you've decided on the zip code to enter, check the correct box in Section 5 and enter the zip code in Section 6. Entering a zip code in Section 6 is required for small claims filed in Los Angeles County, so do not leave it out. Go ahead and complete the remaining sections. If you're suing a local government, such as a city or county, remember to check Yes in Section 8. And don't forget to sign and date the form at the bottom of page 3. After you have completed Form SC-100, you must file it with the clerk at the correct venue. You can use the filing court locator on the LA Court website to determine where to file. Enter the city and zip code of the address, and the search results will tell you the venue where you need to file. In LA County, you are only required to submit one copy of SC-100. You can file your SC-100 in person, though COVID-19 restrictions may require you to make an appointment first. For instructions on filing by mail, fax, or other means, visit the Filing Court Papers page on our website. E-filing is not expected to resume until 2021. The court clerk will process your paperwork and return to you stamped copies that will be used to serve the court papers on the defendant. You'll also receive a copy for your own records. Serving court papers. You've successfully filed SC-100 and received back the stamped copies from the court clerk. Now, it's time to serve the court papers on the defendant. This part of the small claims process is designed to ensure that the defendant is aware of the claim that you have filed so the rules are strict and must be followed closely. If a mistake is made while serving the defendant, you may jeopardize the outcome of your case. There are 3 sets of rules that you must follow when serving court papers in small claims. 1. Who can serve court papers? 2. Where court papers can be served? 3. How court papers can be served. First, as the plaintiff, you are not allowed to serve court papers yourself. By law, someone who is not one of the parties to the case must serve papers on the defendant. In practice, it's wise to exclude anyone who stands to benefit directly, financially or otherwise, from the outcome of the trial. Instead, you must have a disinterested person, at least 18 years of age, serve the papers. Disinterested persons include the sheriff's office, a registered process server, or even a friend or family member. If you ask a friend or relative to serve court papers on the defendant, make sure that they complete SC 104, the form for proof of service, and submit it to the court at least 5 days before the hearing date. Second, small claims rules of service require that court papers be served in the state of California. There are only 2 exceptions to this rule. If you were involved in a vehicle accident, court papers may be served to the driver or registered owner in the state where they reside. Also, if you are involved in a dispute that concerns California real estate, court papers may be served to the property owner in the state where they are located. If you need to serve court papers on someone out of state and you don't fall under one of these exceptions, then you'll need to file your claim either in the state where the defendant will be served or in California General Civil Court. Third, you must use a valid method of service for it to be recognized by the court. There are 2 valid methods of service in small claims. Personal service, when the court papers are handed directly to the defendant in person, and substituted service, when the papers are handed to an eligible person who is at least 18 years old, other than the defendant. Eligible persons include a person who lives with the defendant or who is responsible for the location where the defendant works or receives mail. When using substituted service, an identical set of papers must be mailed first class to the defendant at the same address where the papers were left. Note that substituted service is the only method allowed when serving court papers on a corporation or public entity. There are different deadlines for serving court papers depending on the method and location. These deadlines ensure that the defendant has adequate time to prepare for the hearing. See the table for the deadlines relevant to your case. Importantly, there are 2 additional methods of service that other courts may allow, but that are not allowed in small claims cases heard in Los Angeles County: service by publication in a newspaper and service by certified mail. If a person is named as a defendant in a small claims case, they have the option of filing a defendant's claim, which will be heard together with the plaintiff's original claim on the court date. A defendant's claim is a request for damages from the plaintiff. A defendant's claim may be related to the plaintiff's original claim, or it may concern an unrelated event. Either way, the defendant must complete SC 120 to file their own claim. If the defendant decides to proceed with a claim of their own, they must submit it to the court and serve papers on the plaintiff following most of the same rules as the plaintiff's claim, but with shorter time requirements. The hearing. Your court date has arrived, and it's time to meet with the judge. Make sure that you've prepared any evidence or witness testimony that you would like the judge to consider. Witnesses should either accompany you to your hearing or provide a written statement using Form MC-030. You may also request an interpreter through the court. The court schedules between 10 and 20 minutes for each hearing. Both the plaintiff and the defendant present their own cases without the assistance of lawyers, starting with the plaintiff. Both sides must submit any evidence they want considered in advance of the hearing. Contact the court to find out the rules for sharing your evidence. Common examples of small claims evidence include copies of contracts, pictures of accidents, repair estimates for damages to property, paid receipts for goods, a rental agreement with a landlord in the case of a rental dispute, a copy of a bad check, or even a police report. After hearing both sides, the judge will decide on the plaintiff's claim as well as any claim filed by the defendant. Both sides will be notified of the decision by mail approximately 2 weeks from the hearing. The judge may or may not announce their decision at the hearing itself, so be prepared to wait to find out. In some cases, the judge will instruct both parties to return for another hearing. The court offers remote appearances for those who prefer to appear virtually or by telephone. Navigate to the LA Court Connect webpage and follow the instructions to schedule a remote appearance. Sometimes, one of the parties doesn't show up for the hearing. If the plaintiff does not show up, then the judge will usually dismiss the case without prejudice, meaning that the plaintiff is not awarded a judgment, but they are allowed to bring their case back to court. When this happens, the plaintiff can file a new claim using Form SC-100 and start the process over. In some cases, especially if the statute of limitations has run out and a new claim cannot be filed, the plaintiff must ask the court to vacate the dismissal and consider the original claim by filing Form SC-105, a request for court order and answer. We'll discuss this form again a little later. If the defendant does not show up, then the judge hears the case and may decide in favor of the plaintiff and enter a judgment against the defendant. To request that the judge cancel the judgment and reconsider the case, the defendant must file a motion to vacate within 30 days, using Form SC-135. And don't forget, the defendant is allowed to file a defendant's claim and have that claim considered at the hearing too. If the plaintiff does not show up, the defendant's claim will still be heard, and a judgment may be entered against the plaintiff. The plaintiff has 30 days to file a motion to vacate to have the case reconsidered. Sometimes, a defendant is unaware of a judgment that has been entered against them by the court. They find out months or even years after a hearing that they owe money to someone who has sued them. In these cases, the defendant can request that the court cancel the judgment by filing a motion to vacate within 180 days of the date the defendant discovered the judgment. If the judge denies the motion to vacate in any of these situations, the party who filed the motion can appeal that decision by filing Form SC-140 within 10 days. Unlike filing a motion to vacate, filing an appeal is a request for an entirely new trial with a new judge. You must once again present all of the evidence and witnesses that you want considered. When a case is heard on appeal, both the original claim and any defendant's claim are reheard, regardless of who filed the appeal. And this time around, either side is allowed to bring lawyers, as well as any new evidence they want to include. There are two reasons a party would file an appeal in small claims. One, they want a judge to reconsider a motion to vacate that was denied, as we just discussed. Or two, they want to appeal a judgment that was entered against them. Appeals against judgments are usually filed by defendants who are unhappy that they lost the case and owe money. Other appeals against judgments are filed by plaintiffs who were countersued by the defendant and ended up losing. Either way, a party appealing a judgment has 30 days to file an appeal using Form SC-140. Keep in mind that plaintiffs are not allowed to initiate an appeal when they lose on their original claim, and defendants are not allowed to file an appeal when they lose on their countersuit. There are two additional forms that the court uses to accept requests: Form SC-105 and Form SC-108. SC-105 is a request for court order and answer. Common uses of this form include requesting a change to the parties named in the case, requesting clarification from the judge to understand how a decision was reached, and requesting that the judge enter a judgment if the defendant breaches a mediated agreement. Form SC-105 may also be used by a plaintiff to request reconsideration of a judgment, even though the plaintiff is not allowed to file a formal appeal with Form SC-140. When filing a request with Form SC-105, you may be responsible for ensuring that the other parties are notified of the request by mail, including parties you want the court to add to the case. For details on this requirement, see the instructions near the top of page 1 on SC-105. Just like serving the original claim, these copies of SC-105 must be served by a disinterested person. But unlike the original claim, this service can be completed by mail. There is also a separate form for proof of service by mail, Form SC-112A, that the server must file with the court. SC-108 is a request to correct or cancel judgment and answer. Common uses of this form include requesting correction of a clerical error, such as a judgment that mistakenly awarded the plaintiff $300 instead of $3,000, and requesting cancellation of a judgment because of a mistake made by the court in applying the law. Form SC-108 must be filed within 30 days after the notice of judgment was mailed. If you have the right to appeal the case using Form SC-140, it is usually wise to file both forms at the same time. Remember, you only have 30 days to file an appeal. If the judge takes longer than 30 days to respond to the request you made through SC-108, and you haven't already filed an appeal with SC-140, then you will have lost your right to appeal because too much time has passed. Collecting your judgment. You've completed the hearing. The judge has decided in your favor and entered a judgment against the defendant, who will be legally obligated to pay you for damages in your claim. Enforcement of the judgment is automatically postponed for 30 days after the mailing of the entry of judgment to the parties. If an appeal is filed, the judgment is postponed until after the appeal is decided. Often, the defendant pays the judgment voluntarily. However, if the defendant refuses to pay, you may need to take additional steps to collect your judgment. Knowing what assets the defendant owns can help you decide what requests to make and which forms to use. If you don't know what assets the defendant owns, you can request a judgment debtor hearing using Form SC-134. If you want the debtor to bring written documentation of assets to the hearing, you'll need to file a subpoena as well, using Form SC-107. At the hearing, you can ask questions about the defendant's income, bank accounts, home, car, and other assets. If you find out where the defendant banks, the court can instruct the sheriff to collect money from their account. If the defendant is a person and you know where they work, you can ask the court to garnish the defendant's wages up to 25% of their pay until you've been paid in full. Both of these actions require a writ of execution from the court. If the defendant is a business, they technically don't have any wages to garnish. However, the court can impose a till tap or a keeper, both of which instruct the sheriff to intercept payments made to the business, and both of which require a writ of execution. If the defendant owns a house or other real property, you can file an abstract of judgment using Form EJ001. The abstract of judgment will prevent the defendant from selling or refinancing the property until their debt to you is paid. This form must be filed with the court and then recorded with the Registrar Recorder Office in the county where the property is located. Be aware that money judgments automatically expire after 10 years. To avoid losing the ability to collect your judgment, you must file a request for renewal of judgment with the court before the 10 years is up. Otherwise, your judgment will no longer be enforceable. We hope that this walkthrough has made the small claims process easier to follow. For further information and links to useful resources, visit the Small Claims section on the Department of Consumer and Business Affairs website. Thank you.
Okay, I'm ready for the first question.
Thank you, Simone. So we have about 6 questions. The first one is, we know that because of COVID, there have been some changes. Can you review the current process and any changes that COVID may have affected?
Okay, so it starts from the very beginning, meaning the filing process. Before, you could just walk into the court and turn in your small claims papers, and you would hand them to the clerk, and you would get your court date. That's not possible now. In order to go into the court to hand them in person, you have to make an appointment with the courthouse because they are limiting the number of people who are able to come into the building. The other part of the filing process that has changed is at this moment, our e-filing is not operating. So they expect it to be up and running sometime in 2021. We don't have an exact date. That means the way that you're able to file now is either in person with an appointment with the court, or mailing it in to the court, dropping it into the drop box in front of the courthouse, or you can also fax file. So those are your options. The second part that has changed is how we submit evidence. Prior, we were able to simply tell the litigants, both the plaintiff and the defendant, please bring all your evidence to the hearing, and you exchange it with the other party, and you give a copy to the judge. Now the court has said they want to have the submission of the evidence to the court at least 10 days prior to your hearing date, and you also have to establish that you sent the other litigants, the other parties to the case, the evidence that you want the judge to review. They also have to be in receipt of it at least 10 days before. Now, when you file your case, the court returns to you the specific instructions how you're supposed to do that. So I'm going to tell you what the form is that should be included with your filing when you get it back from the court. It's called Exchange and Submission of Evidence, and the form number is LASCIV 278 and 279. And if you need additional copies of these because you didn't get it from the court or they were misplaced, you can find them on the court website, which is LA Court. Now, the other part that has changed is the court has made it very easy to have remote appearances because a lot of people are reluctant to come in person, and they feel it's safer to request to appear remotely. So that is available to both the plaintiff and the defendant, and you can request a remote appearance by going to the LA Court website. And there is a selection that you would click, and you could say LA Court Connect, and I want to appear remotely, either just by phone or it can also be by video. There is a charge for this. It's a reasonable fee. If someone has a fee waiver, that's going to cover the cost of appearing remotely. So those are the significant changes that are occurring now. Always check our website and the court website to see if they're adding any additional changes, because this is very much in flux, as this is a new experience for all of us, and we're always trying to make changes that facilitate you being able to present your small claims case. So I hope that answered your question. If you have any follow-up, then put it on the chat and we'll get back to you. Okay, next question, please.
Yeah, thank you, Simone. So we're getting a few questions on landlord-tenant. So it may be a combination of some put together, but if you're able to answer them, please let us know. Some of these may be referred over to one of our other programs, which is our rent stabilization program, to get further assistance. If that's the case, please let us know, and then on the chat, we'll also put the phone number where they can reach us. So the issue is, if the issue is a landlord-tenant case and includes an eviction, would the landlord have to file two cases, one for the unlawful detainer and one for small claims?
I'm going to say yes, because you cannot do an eviction in small claims court. So small claims court is for the collection of money. Now, as I said in the beginning of the video, that Assembly Bill 3088 is talking about rent that's due during the time of the COVID rent moratorium period, which began in March of 2020. So there are going to be certain modifications in terms of how much you sue for, how much is considered to be due, because the tenant is entitled to pay back that past due rent by making installment periods over a period of time. So you might not be awarded the total amount of the judgment that you want for the unpaid rent. I highly suggest you call up our rent stabilization department first, because some of the rent that you might be claiming could be before March 2020. That's not protected. So you could sue for the entire amount if the person didn't pay you rent in January and February. But there might be restrictions if they didn't pay you after March. So before you do anything with small claims, double check and speak with our rent stabilization unit. In the near future, we're going to have additional information on our website regarding this bill that will answer your specifics more clearly. So none of the COVID rent can actually be filed until March of 2021. But we want to prepare, and we expect in the next month or two to provide additional information on our website. Okay, thank you. Next question.
Okay, so we're getting a lot more questions. They're coming in. Thank you, everyone. If you have questions, please put them on the chat, and we're going to go through them and answer them as best as we can. So the next question is, again, is the landlord-tenant issue. So tenant shortened the rent of about $8,000, plus about damages of approximately $2,000. The consumer has now sent them a letter indicating of how much is owed, but the tenant has ignored the letter and has not paid. How soon can the consumer file in small claims to sue the tenant?
Okay, so I'm going to qualify that also. If the unpaid rent is during the period of March 2020, ongoing now, that's going to have special provisions. So I'm going to answer as if we didn't have a pandemic, where this was just ordinary back rent. So if that's the case, then the landlord could file a small claims case for the entire amount due as soon as the rent is past due. So there wouldn't be any restrictions, and the maximum that they could sue for is $10,000. So you cannot split the claim up, meaning that you're going to take a larger amount that's due and divide it up into two small claims. But with the Assembly Bill 3088, if it's all of the COVID rent, there aren't any restrictions on the $10,000 small claims maximum, so you could in fact sue for more. So this is always a difficult question to answer during this moratorium period. You need to first get to the rent stabilization unit so that they will counsel you on what your rights are for a tenant and for a landlord. And after they counsel you, then come back to us and ask us the question. Okay, thank you. Next question.
Thank you, Simone. Okay, so the next question is, the litigant is unable to collect their judgment. The defendant is currently not working. Do we have any other suggestions on how they can go about collecting their judgment?
So when you want to collect a judgment, the first thing you ask yourself is it collectible? So for instance, if a person has a regular job, they haven't been laid off, and they have a bank account, then all of the methods that were listed in the video that you watched are going to work for you. But in this economic times now, you in some ways have to profile your debtor. If the debtor is not working and doesn't have any assets now, you're going to have to wait because you can't get any money for which they don't have. Now, fortunately, judgments are good for 10 years. So we expect that, let's say, in the next 6 months, if things normalize and we get our jobs back, etc., then you are able to collect at that time. But if you have checked out the circumstances of your debtor and you see that they're not doing well at this time, your best thing is just to wait. So that is my suggestion. Okay, next question.
Great, and that answers another question that had came in from the public or attendees, and it was relating also that the defendant is hiding and they're unable to collect. So if we did not answer your question specifically, please drop it in the chat box one more time. Perhaps maybe your question might be a little bit different than what Simone just answered. Okay, on to the next one. How about car accidents? Would I fill out the small claims form? It did not require medical expenses, but $1,000 deductible. Would a small claims for $8,000 be reasonable with the other driver responsible with the expired license?
Okay, I'm going to try to answer it this way. You're able to sue for the entire amount owed. So if the total expenses, etc., are, let's say, $10,000, you can sue for that. But if the insurance company has covered a lot of your expenses and they're aware that you do have been reimbursed for those expenses by the defendant, the insurance company could ask for their share. So there's nothing stopping you for asking for it, but the part that is covered by insurance could be possibly collectible by the insurance company from you. So that's something to think about. So we don't give legal advice, so we can't tell you, exactly what to do, what to sue, but you certainly do want to claim any out-of-pocket expenses that you did have to pay in terms of your deductible, anything with the repair of your car, rental car expense, and if there are passengers in the car and they have been affected by personal injury, each passenger should file their own claim against the defendant. So it's preferable not to lump all the defendants together on one claim, especially for personal injury, but for each to file their own claim. And be sure to list both the driver and the registered owner, as they're both legally responsible in a car accident. Thank you. Next question. I can't hear you, Jessica. I can't hear the question.
Sorry, I thought I had clicked unmute. Can you hear me now?
Yes, I can hear you now.
Great. Okay, so the question is, can an attorney represent a corporation during a small claims hearing? And how can evidence be submitted in defense?
An attorney cannot represent any party in the initial hearing in small claims. So if I am suing Apple Computer, they don't send their lawyer. They send someone from the corporate office who is going to have knowledge of the situation and serve as a representative for the company. The only time an attorney can appear is if I happen to be suing someone, and that's their occupation. So if I'm suing my neighbor because their tree fell on my house, and my neighbor happens to be a lawyer, well, then, of course, he can represent himself. Now, when attorneys can appear is on an appeal. So if a individual or a company loses the case and then it is appealed, then you can be represented by an attorney. Now, I want you to repeat the part of the question that talked about how evidence is exchanged or submitted. So would you please repeat that part of the question?
Yes. So it says, and how can evidence be submitted? It says in defense. I'm assuming it's for the defendant side. If I am mistaken, please correct me on the chat. But how can the defendant submit their evidence? Oh, and you might want to mention, Simone, fairly soon we are going to be uploading, submitting evidence, submission of evidence and exchanging of evidence also on our website. Should we not answer the question to its entirety, the video vignette will be available hopefully this week.
Okay, so as I answered in the first question, it talked about how things have changed because of COVID-19 and the new rules about submission of evidence. So whoever is suing the plaintiff, they have to submit the evidence to the court at least 10 days prior to the court date and also to the other party. So now the person who's being sued, they have been notified that they are going to be a defendant in this case. They want, even if they don't file a defendant's claim, they still want to present their side of it to show that they don't owe any money. So they have to submit their evidence the same way the plaintiff did. So it's the same forms, it's the same procedure. In the video that's going to be shortly up on our website, it says, what if the defendant doesn't have the full 10 days to submit it? Because what if they were just served the court papers and they were given the evidence from the other party, but oops, they only have 8 days left? Our suggestion is follow the procedure, submit the evidence as it states, even if it might get there less than the 10-day minimum period, and the judge would decide at the time of the hearing if that's okay under these circumstances, or the judge might schedule a continuance so that the other party has the full 10 days to review the evidence from the defendant. Okay, thank you. Next question.
Okay, so we have a few more questions. So we only have about 7 minutes, so we can start wrapping up some of these questions. If you do have any additional questions, what we can do also is we can send you a private chat, so that way you can provide us your contact information just in case we don't get through all of the questions, but we'll try really hard to get through them in the next 7 minutes, okay? So the next one is, can an individual use small claims court to initiate a criminal lawsuit, or do you have to have a law enforcement or the DA handle that?
All criminal cases are brought by the district attorney's office. So if I have been a victim in something that I believe was a criminal activity, I report that to the police or to the DA or city attorney. What small claims does is you are allowed to ask for damages that that person has done because of the criminal activity. So it's really separate. Your small claims case might be stronger if you come to court and have the judge be aware that there is a criminal conviction against your defendant. But it's not related. So small claims is not the entry level for any kind of criminal prosecution. You have to report that directly to the authorities, and they're the ones who prosecute. Okay, next question, please.
Great. So we have been getting a lot of questions on interest. Can you share a little bit of information on charging interest, please?
Okay, now there's something called prejudgment interest and postjudgment interest. So for instance, if I loan somebody money and they owe me the sum at a certain date, and in the contract it says, if you pay me after this date, there's going to be 5% interest added annually for any amount that hasn't been paid. When you go to court, the judge will evaluate that and might award you what's owed plus the amount of interest the person is delinquent because it's in the contract because they didn't pay you timely. So that is the prejudgment interest. Post-judgment interest is after the entry of judgment and it's finalized, then it's part of the Code of Civil Procedure that judgments accrue 10% interest annually from the date that the judgment was entered. Now, if you have a judgment, let's say for $1,000, and interest would ordinarily accrue at 10%, which is $100 a year. But let's say the judgment debtor, the one who owes you the money, has made a partial payment. They gave you $200. That money that they are giving you is first going to go towards the interest. So if they pay you $200 after 1 year that you have the judgment, then what happens is the judgment of $100, the interest of $100 is going to be taken out of the $200, and then the remaining $100 is going to reduce the principal. So just so you understand that any payments that you get after the entry of judgment, it first goes against the post-judgment interest that you are entitled to. If you have any other questions, then we'll follow you up in the chat. Okay? Next question.
Yes, thank you, Simone. So because of time frame, we only have about 3 minutes. We'll answer one more question. Again, if you do have additional questions that we didn't get to answer, please leave us your name and your contact information and maybe even a brief message as to what your questions are. We'll go ahead and have somebody give you a call back or contact you within 48 hours, okay? Just in case, I know we have a lot of questions and they're really, really good questions, but because of time, we can only answer so many. Okay, last one. Can the plaintiff include any fees incurred for legal counsel that the plaintiff felt was needed to be supported, even if the support was about the complex procedures?
If you're going to include additional costs that you have incurred when you're bringing the case before the judge, you would need to ask the judge at the time of the hearing, meaning, let's say I want to have a sheriff serve the court papers. Sheriff fee is $40. But this person is very difficult to serve and the sheriff isn't able to catch them in at their home at an appropriate time. So because of that, I have to hire a private process server. That might cost me $150. At the time of the hearing, I would tell the judge, please add additional service fees to the judgment because I was unable to serve easily through the judge, through the sheriff, which is $40. Now, the same thing with attorney fees. You would tell the judge at the time of the hearing, these are what my expenses are. I had to consult with an attorney to find out my rights as a landlord, et cetera, et cetera. You bring the receipts to court. Of course, now with the submission of evidence 10 days prior, include those receipts, those attorney costs, along with your other evidence when you turn it into the court, and the judge will decide at the time of the hearing if those are acceptable expenses to add to your judgment. Okay, so as I understand, that is our last question. So I wanted...
Just one quick thing, because we have a high demand, I think what we'll be doing is next week, next Wednesday, at the same time, we'll be presenting this video and this webinar all over again. So if you have additional questions, please feel free to join us again. We'll be hosting it again next Wednesday. The registration link will also be available on our website and will be notified the same way that you received this notification. Thank you all for joining. Simone, do you have any final thoughts?
Okay, I also want to thank you for coming, and I want you to remember to check out our website where we will have this video posted, and also we have tremendous resources that are listed there that can help you in all different parts of the small claims process. Now, one little reminder, it would be very helpful to us if you would complete the survey, so that'll let us know how we're doing and how we can do better. So thanks again, and we'll be back next week. Okay, bye-bye.